sia pure in senso indiretto, l'avevamo anticipato ieri, di debito pubblico, di debito sovrano, debito degli stati, e oggi torniamo un po' da dove siamo partiti in senso lato, anche come OCI, come associazione, siamo non in fin dei conti ma nei conti, un'associazione di magistrati che si occupano di crisi di imprese, quindi hanno confidenza quotidiana, pratica, operativa e comunque teorica con i debiti delle imprese, sono quelli che vengono trattati giudiziariamente, ed è abbastanza simbolico, oltre che accuratamente frutto di lunghe discussioni preparatorie, che l'ultima giornata si concluda proprio sui debiti di nuove soggettività, gli stati, debiti di tradizionali soggettività, le imprese. Nell'ambito di questa conclusiva sessione di InsolvenzFest abbiamo un particolare onore, quello di ospitare uno dei più importanti studiosi europei, oltre che professore in Germania, il professor Christoph Paulus, che è ordinario di diritto delle procedure concorsuali all'Università Humboldt di Berlino, che sarà intervistato, o per meglio dire dialogherà direttamente con un altro recente amico 2014 di OCI, il professor Scarso, che insegna diritto privato, come è noto, alla Bocconi di Milano. Il professor Scarso molto generosamente ci aiuterà anche a tradurre per brevi spezzoni gli interventi del professor Paulus e degli stesso aggiungerà ricchezza di materiale attorno al tema che insieme affronteranno, e cioè i debiti delle banche nelle procedure concorsuali, in particolare nei fallimenti, e come la messa in sicurezza delle passività, in particolare bancarie, viene diversamente regolata. Accenno subito a una questione che credo interesserà molto i pratici che sono presenti oggi a seguire questi lavori. Considerate, ma ne parleremo durante la sessione, quindi sceglieranno loro il momento, ma sarà molto evidente, che in Germania nel 2009 hanno adottato una soluzione molto rigorosa, apparentemente intrasportabile altrove, che è quella di abolire tutti i privilegi del fisco. Loro ci spiegheranno le ragioni, ci spiegheranno che il sistema non è saltato per aria, in quanto ci sono altre forme di compatibilità che lo rendono ordinato, come non poteva non essere in Germania. E questo è uno degli aspetti di curiosità non antropologica ma culturale, scientifica e ordinamentale che credo muoveranno la vostra attenzione verso questa sessione, per la quale appunto chiedo al professor Scarso di iniziare.
Sì, grazie Presidente. Innanzitutto desidero ringraziare per l'invito che ho accolto ben volentieri e sono veramente molto contento di poter, dare il mio piccolo contributo nel dialogare col professor Paulus. E vorrei fare una brevissima introduzione per quanto attiene al principio della par condicio creditorium, posto che spesso quando si accosta questo principio della par condicio creditorium alla materia fallimentare, alle procedure concorsuali, sembra quasi che si tratti di una insigne banalità, posto che si è sempre ritenuto, si è indotti a ritenere spontaneamente che sia la materia fallimentare il regno della par condicio creditorium. Del resto è sufficiente considerare sia dottrina che giurisprudenza, dove il principio dell'uguale trattamento dei creditori per certi versi assurge quasi a un leitmotiv. Basti prendere un qualsiasi manuale di diritto fallimentare per riscontrare come talvolta viene ex post quasi conferita razionalità a una determinata soluzione, invocando il principio della par condicio creditorium, ovvero fa riferimento alla giurisprudenza dove viene richiamato in ambito di revocatoria, in ambito di rapporti pendenti, in vari ambiti, sempre evidentemente come elemento rafforzativo per quanto attiene in particolare a una determinata soluzione che è stata adottata. In questa prospettiva la mia prima domanda al professor Paulus è proprio chiedersi qual è in realtà il fondamento, ammesso che ci sia, della par condicio creditorium. So, Professor Paulus, I was just saying that whenever somebody refers to insolvency proceedings, the normal and usual approach is to take for granted that there is a principle of equality of treatment of creditors. So my first question to you would be, is there any specific rationale behind that? Because legal scholars tend to believe that it is some sort of a law of nature, some sort of striving for an absolute value. And how is that in general? And the second question, the follow-up question would be, how's that, for instance, in particular with reference to the German insolvency proceedings?
Thank you very much. I do have to apologize to all of you that I'm not speaking Italian. I must say, I was introduced very kindly. Thank you very much, Massimo. But I was not introduced as what I'm really am. I'm a professor also for ancient Roman law. And under these circumstances, I've written a long book about ancient Roman law. And I've read numerous books in Italian, and I never made it to speaking Italian. So please forgive me that I'm now speaking English. Thank you very much for your patience with me. And thank you very much for the introduction, which is entirely wrong. And it's me who is flattered and who feels extremely honored to be here, to be invited. But now to your question, Alessandro. That is a fascinating question. What is it all about, this par conditio creditorum? I was once working as a consultant for the World Bank in 2006, and I was supposed to write a report about the importance of the par conditio creditorum. And it was extremely hard to find rational arguments in favor of the principle. So my main answer to your question would be it's a psychological phenomenon. If I am bound to lose something together with all of you, we are together the group of creditors of Alessandro. And we know that we might lose something. Then it's a matter of the feeling of fairness that I don't want to get treated worse than you or you. You might have heard of there's a psychological game, the ultimatum game. Have you ever heard of the ultimatum game? It's an interesting test which has been done for something like 30, 40 years. It was initiated by economists, behavioral economists, and they wanted to prove that we humans are greedy persons. And they made the following game. I pull out 50 euro. And I look at these two gentlemen on my panel. And I tell to Alessandro, you will get these 50 euro and you can keep it when you divide it between you and Massimo in which way soever. However you divide these 50 euro, if he agrees, then you can keep the money. But if he says, no, I don't want to have this division, then I take the 50 euro back. The economists expected that we are greedy persons, economical thinking, and they thought he would keep 49 euro and offer 1 euro to Massimo. And think about it. I mean, Massimo would earn 1 euro for just saying, fine. I mean, it's a good bargain. But of course he says no. You are shaking your head. Of course he says no. In our cultural circle, Alessandro would have to say, okay, 25-25. It's 50. It's 50-50. So the consequence thereof is usually drawn by the scholars that we have a feeling of, an innate feeling of fairness. And this is what I see as the ultimate justification for the principle of par conditio creditorum. Economists are stepping in and they add another argument. They say, if you have the par conditio creditorum, you have the best controlling system. Because then you are losing like the other ones as well. You must fear constantly that you lose money together with these others. And therefore you control and check your debtor. And this is not the case when you are privileged. I mean, that's the big problem, and I think we'll talk about it. That's the big problem of a privilege. You stop controlling because you can lean back and you can say, do what you want because I will be treated anyway. I will get my satisfaction, and that's all what I'm caring about. If you are in this position, it begins what economists call the moral hazard. And the moral hazard is what we come back in the case of banks, where the moral hazard, and this is the result of my most recent research, the moral hazard created with the privilege that they had was the main reason for the financial crisis which began in 2007. Now I'm coming to your second question. Right, forgive me.
No, mi è stato, per quanto dia per scontato che tutti o quasi abbiano perfettamente compreso, mi è stato chiesto di offrire una brevissima traduzione, per cui mi limito all'essenziale, e cioè, come credo sia comprensibile a tutti rispetto a quello che ha detto molto chiaramente il professor Paulus, in realtà le ragioni sono di due tipi. Innanzitutto una ragione di carattere lato sensu psicologico, quindi teoria dei giochi, da noi credo sarebbe il dilemma del prigioniero per certi versi, che induce comunque a far sì che al di là di quello che può essere il beneficio marginale, in ogni caso si preferisca proprio a livello di esperimento psicologico una parità di trattamento. Proprio l'esempio che è stato fatto con la suddivisione dei 50 euro alludeva a quello. In secondo luogo una ragione di carattere economico, che senz'altro credo maggiormente di rilievo, soprattutto nella prospettiva dei privilegi in Germania, ossia ritenere che nel momento in cui un creditore sapesse che il proprio credito è assistito da un privilegio, non è indotto a monitorare la posizione del proprio debitore e quindi nella prospettiva di un fallimento. Just my second question, because I wanted to add something with reference to that. Obviously, I would not expect that in Germany, tax authorities waived the right they had to be granted a priority treatment due to some sort of psychological reason, even though this is quite important. I would assume that it was much more relevant. I mean, the economic background, for obvious reasons. Maybe before I ask you for, the line of reasoning behind this amendment that led to the waiver by tax authorities, just to offer you an insight and to offer also a brief commentary with reference to the situation we have in Italy. We have a principle that says, as a matter of principle, you should have equal treatment of creditors apart from mortgages and pledges, and apart, obviously, from privileges, but that would be section or article 2741 of the Civil Code. If you look at privileges, at existing privileges, I was myself surprised to learn that there's something like 30 privileges on movable property, that is to say, on the receipt on what you will get if you were to sell movable property as a consequence of an enforcement proceedings. And there are some 12 to 13 privileges, apart from a mortgage, apart from a pledge, that will apply with reference to immovable property. So obviously, from an Italian perspective, taking into account that historically, normally, claims by tax authorities have been assisted by a privilege, it's quite surprising to learn, all the more if you consider the overall economic situation, that Germany or German parliament, in the end, passed statutory provision that were providing for the waiver of this privileges assisting claims by tax authorities. So maybe my question would be, you could outline the line of reasoning behind that, and also, the reaction both by tax authorities and as well as in terms of the political environment.
This is a fascinating question again. So in 1999, we have abolished the old bankruptcy code, Konkursordnung, and have replaced it by the modern insolvency ordinance, Insolvenzordnung. And in this new code, we have the statement that all unsecured creditors are treated equally. So there is, allegedly, no privilege left. And we had the fiscal privilege before. So they had, this kind of moral hazard that they could be very reluctant in filing a petition at the bankruptcy court because they would get satisfaction anyway. And here comes, we have seen in Germany, we have seen this model in Austria. We have taken this as a model from Austria. Austria has begun with creating the abolition of privileges. And the reason is that debtors who are in financial difficulties, they stop payments where they feel that it's not so important to pay them. They will pay their workers. They will pay those who deliver goods for them. But they stop immediately paying taxes. So by means of indication who is going to become bankrupt, this is probably the best indicator. And that was actually the idea of the German legislator. They said, again, the tax authorities up to now, that was in 1985 to 1994, the legislator said the tax authorities have the moral hazard that they do not file a petition. They accumulate a huge amount of debt because the debtors won't pay them. And the banks know this guy has problems, is in financial difficulties. And for that reason, they wanted to make use of this early indication, because this is what you all know. The earlier you file a petition, the earlier you begin an insolvency proceeding, the better are the chances for recovery, for restructuring. And in combination with the new law having a kind of Chapter 11 proceeding, what we call planned proceeding, where we wanted also to increase the chances for restructuring, this was seen as an ideal tool that the tax authorities immediately go to the bankruptcy court and file a petition. That was theoretically a wise idea. The practice, however, is pretty much entirely different. The tax authorities, from the very beginning on, they fought for reintroducing a privilege. They wanted to have their privilege back. They still today are fighting. In these days, in these weeks, again, they are fighting. A couple of years ago, something like 5 years ago, the finance ministry, which is, of course, the top authority for the tax authorities, they initiated a single section in a statute on social security. And that was meant to reintroduce at least part of the former privilege, of the fiscal privilege. And why did they do so? Because it was social security. Social security legislation goes from the Ministry of Social Affairs to the Parliament and then gets enacted. And the Ministry of Justice is not involved. The Ministry of Justice is in charge of insolvency law. So it was on purpose. It was a detour around the Ministry of Justice. And then all of a sudden, there was the privilege enacted in a new statute. And you know what? I feel ashamed as a German. The German Supreme Court, finally, in the last decision said, we do not apply this law. because this is unconstitutional. That is, they found a tiny little mistake, which they said, which is so grave that we can't apply this law. I mean, this was a flagrant ignoring of what judges are about to do. They have to apply the law. And they just refuse to apply the law. And funnily enough, the legislator, the parliament, struck out this section. It was annulled afterwards. So they learned the lesson, they got the lesson, and have pulled it back again. So it's very silly. It reminds me very much of a kindergarten. It is this game, give me back what I had 15 years ago. It's amazing.
Riassumo, come di consueto, brevemente quello che ha illustrato il professor Paulus, ossia che le ragioni, o la ragione principale è stata una ragione di efficienza del sistema economico complessivamente considerato, ossia l'importanza di intervenire quanto prima a fronte dei primi segnali di crisi dell'impresa, ed evidentemente tra i creditori che vantano una posizione privilegiata senz'altro c'è l'amministrazione finanziaria, proprio perché l'imprenditore in difficoltà tendenzialmente non paga le imposte, o quantomeno può essere indotto a non pagare le imposte, ed evidentemente il fatto di poter contare su un privilegio avrebbe in questa prospettiva disincentivato una possibile azione esecutiva, addirittura la presentazione di un'istanza di fallimento da parte dell'amministrazione finanziaria. Ciò nonostante, a livello lato sensu politico, sono stati intrapresi diversi tentativi da parte dell'amministrazione finanziaria per poter di nuovo, poter disporre di questo privilegio per quanto attiene crediti erariali, che nonostante sia stata anche emanata una apposita norma legislativa, di fatto è stata disapplicata da parte del Bundesgerichtshof.
Sure. Maybe you can help me. I'm thinking about the fiscal privilege now for something like 20 years. And I feel again something extremely unfair in that the sovereign, the legislative branch of the state, is creating a privilege for the benefit of itself for the tax authorities. It reminds me, forgive me, it's a ridiculous example which I always bring in my class in order to make it really understood by the people. It reminds me of my brother. I have a brother who is 7 years older than I. So when I was young, he was strong and he always kicked me. So, and when he wanted to play, he said, "You play with me." And then, of course, I played. And he had these tiny little warships. And he said, "Let's play warships." And then he gave me a few, the bad ones, and he kept the good ones. I mean, it's this kind of power game. And then the decisive point. He said, "You, Christoph, that's me, you are the Russians, and I'm the Americans." And this meant he wins. This was clear from the very beginning. And I feel reminded when I see this fiscal privilege, because the fisc has the power. It's my big brother. He says, "I get a privilege, you don't." There is something unfair, and I'm still looking for a constitutional explanation of this unfair, of this unfairness, but I have not yet found.
I don't think I need to translate. In the sense that, I mean, it's I know in the sense, no, do not misunderstand me, in the sense that I'm firmly convinced that everybody understood what you referred to. There are a few remarks that I would like to make with reference to what you said. First of all, one information which probably or maybe is not known to everybody here in the audience, which refers to the turnaround and to the importance of implementing some measures in order to make sure that you rescue certain business. There's a specific statute, I just can switch to Italian. Lo dico in italiano perché tanto comunque, obviously you know the content of section 15. No, c'è una disposizione specifica nella legge fallimentare tedesca che viene effettivamente applicata, che è il paragrafo 15 della legge fallimentare tedesca, a tenore del quale, 15A, esatto, a tenore del quale nel momento in cui l'imprenditore si trovasse in una situazione di, noi diremmo, stato di insolvenza, lì si parla di illiquidità o sovraindebitamento, ma concettualmente si sovrappone alla nostra nozione di stato di insolvenza, deve presentare istanza di fallimento al più tardi entro 3 settimane dal momento in cui si è manifestato lo stato di insolvenza. Ed è una norma presidiata da una sanzione penale, che implica che comunque sia, evidentemente, viene presentata tempestivamente istanza di fallimento, piuttosto che hanno delle procedure simili a quello che sarebbe poi il nostro concordato preventivo, ma ne parleremo in seguito. Seconda osservazione, si parlava poc'anzi della motivazione principale che ha portato all'abolizione del privilegio che assiste i crediti erariali, e il professor Paulus ci ha illustrato come la ragione fosse quella innanzitutto di evitare questo trattamento differenziato che non trova alcun fondamento, ma soprattutto anche di promuovere, almeno nelle intenzioni, una azione incisiva e tempestiva da parte dell'amministrazione finanziaria, che in questo caso avrebbe potuto o potrà presentare istanza di fallimento. Inutile dire che il quadro italiano lo conosciamo tutti, anche solo per riscontrare il mancato pagamento dell'IVA, quindi parliamo oltretutto di un'entrata proprio dello Stato, che io sappia, probabilmente ci sono delle differenze tra singole regioni, ma in media ci vogliono 4 anni. Quindi porsi in questa, se non di più, porsi in questa prospettiva in Italia purtroppo per molti versi fa sorridere. Quello che invece è, se così vogliamo, un'innovazione, and now I switch to English because I refer to some recent amendments of statutory provisions that we had in Italy. We do not have something similar to this idea of having, for instance, tax authorities filing a petition or, for instance, abolishing this sort of privilege assisting their claims in order to have them filing a petition, because it takes 4 to 5 years with reference to the VAT tax for them to realize that actually you did not pay it. But what we have is we have the possibility of tax settlement or a settlement with tax authorities as a consequence of the introduction of some schemes, voluntary schemes of arrangement, and in particular we have 2, which would be debt restructuring arrangement and a judicial composition with creditors. Both of them grant the possibility, for instance, for a debtor to apply to the tax authority and to reach some sort of settlement agreement. So my question would be, given, as far as I understood, you already said that actually even though there's no longer a privilege, German tax authorities will not file a petition seeking the adjudication of bankruptcy of a business of a debtor. Is there any possibility, maybe also within voluntary schemes of arrangement, to have or to reach a settlement with tax authorities in Germany?
The more or less clear answer is no. There are numerous regions in which the highest tax authority explicitly states there is no composition, no agreement with any debtor. We agree to nothing. So we want to have full satisfaction, or at least a full liquidation proceeding and the distribution in this liquidation proceeding. This is, of course, kind of stupid because, as Alessandro mentioned, modern insolvency law in general, particularly here in Italy, but it began in France and in the United States and in England. Modern insolvency law is not any longer liquidation, it is also reorganization. And now it's getting even earlier. It's the avoidance of insolvency proceedings, which nowadays is insolvency. If you have the option of reorganizing the debtor, then of course it cannot be done that one of the creditors is by definition never agreeing to anything. if you want to have a restructuring of a debtor, you need to restructure the debts as part of the entire game. You need usually that the creditors waive some part of their claims, or that they agree to a prolongation of the repayment date. But if you have one creditor who says strictly and without exception, no, I don't do that, then you have problems with this rescue culture. And you might know that the rescue culture is now something which the European authorities have put on the agenda. It is this concept of second chance. And it was only in March of this year that Europe obliged the national legislators to enact insolvency avoidance mechanisms in order to improve the rescue measures in our countries. Because they have seen that the bankruptcy, the fallimento, is, speaking in terms of macroeconomics, a dangerous thing. We have to improve where we can improve. We have to rescue where we can rescue. And now, because we have in Germany this contradiction between tax law and insolvency law, it was only 6 months ago that the government has set up an organization of experts who shall find compromises between tax law and bankruptcy law. So, and we don't know yet what the result will be from this.
Allora, in realtà questa possibilità di avere una sorta di transazione a seguito magari di procedure concorsuali o comunque disciplinate da noi quantomeno nella legge fallimentare, in Germania non sussiste, nel senso che comunque l'amministrazione finanziaria non è disposta a rinunciare a parte del proprio credito per quanto non assistito da privilegio, e diceva il professor Paulus, ciò pone un problema nella misura in cui ci si ponga nella prospettiva di una ristrutturazione del debito o comunque di una procedura volta al rilancio di fatto del debitore, quindi sostanzialmente dell'azienda, perché nel momento in cui ci fosse un debitore e che in ipotesi avesse anche crediti di una certa consistenza che di default, per così dire, insiste sul pagamento integrale, è evidente che ciò può porre un ostacolo talvolta insormontabile a una prospettiva di ristrutturazione, il che oltretutto andrebbe anche contro quello che è il nuovo orientamento a livello comunitario di preservare l'avviamento, quindi di preservare la continuità aziendale in capo al debitore insolvente o comunque che si trovi in uno stato poco prima della insolvenza. With reference to what you said, I think the first a follow-up question would be, I assume that there are some sort of insolvency proceedings or proceedings that are ruled in the insolvency statute where you have a cram down, because what we would have in Italy in that case is you have the composition with creditors, and the composition with creditors provides for a cram down. That would be the first question, but I would like to take the opportunity to outline the statutory framework and to refer to two additional questions. The starting point with reference to the additional questions is that obviously if you refer to statutory provision, you need to have a consistent statutory framework as a whole. So you mentioned the fact that in Germany in 1999 the privileges assisting claims of tax authorities have been abolished. Now what I think is interesting is one, how does that impact on the avoidance action or the clawback action, as obviously the avoidance action in the end from a substantial viewpoint is just like anticipating the principle of equality of treatment of creditors to the months or years preceding the adjudication of bankruptcy. The second question, and now I'm back with reference to the schemes of arrangement, voluntary schemes of arrangement. I mentioned that you would have in Italy, with reference to the composition with creditors, with reference to the concordato preventivo, a cram down. And as we are talking about the principle of equality of treatment of creditors, one of what I believe is definitely unfair in Italy is you can divide the creditors into different classes, formally according to the uniform economic interest that they have. This specific provision is applied in Italy as meaning that within unsecured creditors, you could easily divide them into different classes by claiming that, for instance, that one is a strategic supplier in order to have or preserve the business as going concern. The other one has, for instance, claims exceeding whatever a certain threshold, 100,000 euros. So I often wonder what the rationale behind this sort of, division within classes is, other than to prospectively anticipate how they will vote, and obviously to have, for instance, a majority, because in order for a composition with creditors to be sanctioned by a court at a later date, you need to have the majority of claims plus the majority of classes, and clearly this leaves some sort of leeway with reference to that, which brings us back to the starting point, the inequality of treatment of creditors.
That is a wonderful point. Maybe in Germany it's less urgent than it is here, because you have the concordato preventivo, which is a procedure which is before an insolvency proceeding. It is a kind of insolvency proceeding, but it's light. We have the planned proceeding within the insolvency proceeding. So we have nothing so far. We have nothing before insolvency. So we get into an insolvency proceeding up to now only when there is insolvency, or at least imminent. But in practice, this is rarely applied. But within the insolvency proceeding, after a couple of weeks, you can decide that you make a planned proceeding, and then in the planned proceeding, in the end, you have this voting, and there we have the cram-down rule. And there you really, as a matter of fact, you can say your no, even so you said no, or your group said no, I deem it to be a yes, provided that the majority of the groups say yes. That is the same as in Italy, as I understand. And then we can turn the no into a yes. I mean, that's a nasty trick. I mean, let's be aware of that. And here comes something what you mentioned, which is rarely addressed, at least in the literature. I'm not a practitioner, and therefore I can't say how they really do it in practice. And it's never written about, but of course, the group formation is done by experienced administrators in a way that the outcome is clear. So strategically, formation of groups, that is what they usually do. They put those who are clear to be the no-sayers, for instance, the tax authorities, into one group. They have to find a justification, because in the statute you find that you have to make coherent groups, and there must be something rational behind the formation. But I mean, we are lawyers. I mean, this can be done. At least in Germany, the administrators are usually lawyers, and they are trained in find some explanation which justifies that this is a group. And that is, as a matter of fact, that is a violation of the par condicio. But the par condicio, the only place in the insolvency ordinance where the par condicio is at least indicated is that within a group you have to treat the creditors equally. So that's the only mentioning where you have the par condicio within a group. And now, this is a big question that you're raising. What is the inner coherence of abolishing the tax privilege and the relationship to the Actio Pauliana? Apologies. Actio Pauliana, you know why it is called Actio Pauliana? Julius Paulus, Christoph Paulus. I've written a commentary on that. Oh, that was nice. The German Actio Pauliana had been strengthened in 1999. In the new insolvency ordinance, we have a much stronger and much stricter avoidance powers, actio Pauliana, than we had before. And it's during the last, in particular, 10 to 15 years that the courts and the practitioners have aggravated the application of the actio Pauliana. It has been broadened enormously. It is a far range of transaction in the forefront of an insolvency proceeding, which nowadays are subject to avoidance powers once the insolvency proceeding is opened. This reaches so far that, again, rescue attempts are in danger or are not even started because the transactions which are made in favor of a rescue attempt, so the payment of a bank, for instance, is potentially subject to revocatoria. And that is, again, an impediment for the rescue culture. And right now, in these weeks, the German parliament, the legal, the particular legislation group within the parliament is considering to soften the German actio Pauliana, because the industry, the general public says this is too dangerous. It doesn't work.
Allora, credo, let me just offer a commentary in Italian with reference to... No, volevo offrire un brevissimo commento a quanto diceva il professor Paulus, ossia innanzitutto riscontrare una coerenza, in questo caso sia in Germania che in Italia, per quanto attiene alla disciplina dell'azione revocatoria. Ossia il professor Paulus ha illustrato come si è ampliata per certi versi, forse a dismisura, l'azione revocatoria, la possibilità comunque di impugnare singoli atti prima del fallimento in Germania, al punto che in Germania ci si interroga circa il fatto di restringere quelli che sono gli atti che possono essere oggetto di revocatoria. Evidentemente, se ci si pone nella prospettiva che l'azione revocatoria altro non è se non garantire, o quantomeno tendenzialmente garantire, la parità di trattamento dei creditori anticipando i tempi a prima della dichiarazione di fallimento, questo ampliamento è coerente con l'abolizione del privilegio, dei privilegi in generale, in quanto evidentemente anche l'abolizione dei privilegi si pone nella prospettiva di garantire l'uguale trattamento dei creditori. In Italia, in prospettiva opposta, non so fino a che punto consapevolmente, siamo altrettanto coerenti, perché sappiamo tutti che a seguito delle riforme del diritto fallimentare è stato ristretto di molto l'ambito dell'azione revocatoria, a parte gli atti a titolo gratuito comunque si parla di un lasso di tempo di 1 anno, ovvero di 6 mesi, in Germania addirittura di 10 anni, ma al di là del lasso di tempo la differenza è essenzialmente quella della tipologia degli atti che possono essere oggetto di revocatoria, il che a sua volta è per così dire coerente con l'avere 30 privilegi immobiliari e 13 privilegi sugli immobili, in quanto comunque se si abbandona l'idea, per così dire, dell'uguale trattamento dei creditori limitatamente a questi profili, è coerente che evidentemente altrettanto valga per quanto attiene a un restringimento dell'ambito d'applicazione dell'azione revocatoria fallimentare. Un secondo commento che volevo fare, e quindi poi passiamo anche alle banche, riguarda quello che in Germania è l'Insolvenzplan, cioè una sorta di procedura disciplinata nella legge fallimentare, di fatto, come ci ha detto il professor Paulus, equiparata al fallimento, una sorta di istruttoria prefallimentare che per certi versi è paragonabile al nostro concordato preventivo. Ebbene, trovo interessante riscontrare come l'accesso a questo Insolvenzplan sia ammissibile solo ed esclusivamente nel momento in cui non ci fosse ancora uno stato di insolvenza, cioè nell'imminenza dello stato di insolvenza, quantomeno come requisito indispensabile a livello di tenore letterale della disposizione normativa. I was just saying that with reference to this turnaround perspective, it's quite interesting to note that being granted access to the Insolvenzplan, to the planned proceedings, if you stick to the wording of the relevant statutory provision, is solely admissible if there is no illiquidity and no over-indebtedness, but an imminent illiquidity and an imminent over-indebtedness, which is quite different if you refer to this composition plan in Italy. So this just confirms the perspective of the importance of the turnaround in Germany. My question is rather, as we are talking about banks, from a practical viewpoint, normally in Italy for restructuring proceedings to be approved by the majority of creditors and then at a later date to be sanctioned by a court, what is of the utmost importance is actually two types of creditors. For one, the consultants and advisors, because they are granted by operation of law some sort of super seniority with reference to their claims. And the second one clearly is, and now we're back with reference to banks, is the position of banks, because normally you will prospectively obviously apply to a bank in order for a bank to provide some sort of bridge loan, interim financing, whatever you want to call. So my question would be, does that apply also with reference to the planned proceedings in Germany, that you have these two types of creditors that in the end will, to a large extent, determine whether it will be approved or not?
Yep. That is a very, very, in particular with respect to the advisors, this is right now in Germany a very big issue. Advisors are, if they receive money in before the opening of the insolvency proceeding, they must fear that the money is revoked, that the actio revocatoria is applicable. And for that reason, you find now kind of strange thing. We have in the rules of the Actio Pauliana, we have one rule which says that certain transactions will not be revoked if certain conditions are fulfilled and when they are paid in, or when they are made in exchange with the consideration. And this in exchange is nowadays seen as something like 30 days. So I deliver something to you, and you pay me within the next 30 days. Then this is something which is done in exchange. And then it is more or less free from the Actio Pauliana, more or less. There are other dangers, but this is. As a consequence, advisors nowadays have in their contract the rule that they claim payment in advance for the next 30 days. And that they will perform in the next 30 days step 1, 2, and 3. And then after 30 days, again, the same type of contract, we'll do step 4, 5, and 6, and you pay me before front. So it's this fight against the actio revocatoria. Regarding banks, your second group of interested institutions, there it's even more complicated. And there you see what sophisticated legislation and adjudication can achieve. The Supreme Court is making a reference that a rescue loan will not be subject to Actio Pauliana when and if the rescue loan was given on the basis of a solid rescue plan. Sounds good. When you read this, then it makes sense. The bank should not just pour money into the debtor, even though the debtor is just saying, well, I will recover and everything is fine. It must be based on a solid plan. What reads wonderful in a particular case is, of course, difficult to define in practice. What is, imagine you are the bank, and I'm coming to you, and I'm telling you, Alessandro Somma did a wonderful plan for me. Here is the plan. And now you have to judge, is it a solid plan? And you don't know what the judges in 10 years or 5 years will say about his plan. And my assumption that it was a solid plan. So there are difficulties. And what I understand, and this would be your remark, that is something where you, the Italian law, are much, much better equipped than we are in Germany. You can go ex ante to the court and you can ask, please confirm that this is okay. We have nothing like that. And if I may respond to this remark, there we have another German problem. And that's a big problem in, at least when you are within Germany. We are a small country, speaking in terms of size. And we have 192 insolvency courts. That is to say, courts which are dealing just with insolvency. So we, of course, we have a court in Berlin, we have a court in Munich, we have a court in Cologne. So these are fine. And there you have judges which are okay, insolvency judges which are okay. But we have something like 170 tiny, tiny, tiny little courts where the judges are, or where you have maybe one judge or two judges. And they are covering the entire spectrum of private law. So you have tiny little courts where the judge is a fifth of its portion is insolvency law, and 4/5 is family law. So these judges, usually quite nice ladies, family lawyer, family judges, they can tell you everything about divorce and how much you have to pay as a father and so on and so on. But when it comes to insolvency, they know nothing. And this is extremely unfortunate when, for instance, there is an application for a big case, for a European case, for instance, then they know nothing at all. They say, help, 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 I can't do anything. And this is the reality in Germany, which is, for political reason, very ridiculous. For political reason, extremely difficult to change. And for that reason, I think we have not this confirmation thing, because this lady, this family judge, she wouldn't know where to look in order to confirm such a bank request. She doesn't know anything about economics. She can't tell you, is it a prudent thing, is it a valid plan, or what is it? So that is probably our problem, the answer to that.
Riassumo brevemente quello che diceva il professor Paulus. Per quanto attiene alla posizione dei professionisti e alla prededuzione dei crediti maturati in relazione alla presentazione di un accordo di ristrutturazione piuttosto che di un concordato preventivo, in Germania non è prevista, ma in realtà c'è una giurisprudenza consolidata che prevede, o meglio, esonera, esclude la possibilità di impugnare con azione revocatoria i pagamenti effettuati, se effettuati in un lasso di tempo di 30 giorni, proprio perché vengono considerati contestuali, ovviamente purché a valori di mercato. Il che significa che ciascun professionista si fa pagare in via anticipata per il lavoro che andrà a svolgere da lì ai 30 giorni successivi. Per quanto attiene alla posizione delle banche, diversamente da quanto accade da noi, dove comunque c'è la possibilità, come tutti sappiamo, con la domanda in bianco dell'accordo di ristrutturazione o comunque del concordato preventivo, di chiedere l'autorizzazione ad effettuare determinati pagamenti o addirittura al contrario nuova finanza, altrettanto non vale in Germania. Diceva il professor Paulus, in linea di principio è esclusa la revocatoria nel momento in cui il finanziamento è avvenuto a fronte della presentazione di un piano diremmo noi, confermato da un esperto ai sensi dell'articolo 67, quindi da una persona che comunque certifica, attesta che quel piano prospetticamente vale a far sì che l'impresa possa mantenere la continuità aziendale. Però tra il dire e il fare, come dire, c'è una bella differenza, per cui ciò non toglie che ex post, soprattutto nel momento in cui evidentemente si è poi verificato il fallimento, il curatore fallimentare non ritenga poi di impugnare questo tipo di azione. E da ultimo sottolineava il problema che peraltro a mio modesto avviso abbiamo anche in Italia, delle diverse, più di 190 sezioni fallimentari dei tribunali, che evidentemente determinano che soprattutto quando si parli di fallimenti internazionali o comunque con risvolti internazionali, il singolo giudice nelle corti minori, che in realtà non si occupa quotidianamente di questioni fallimentari, si trova in grosse difficoltà per quanto attiene alla decisione da prendere. Just with reference to the Italian situation, a brief commentary, I think we have the same problem, even though we have less than 190, I think we have 120 courts, insolvency courts, in terms especially of cross-border proceedings. And I made quite often the experience that statutory provisions related to the European regulation or just like that are not considered to be domestic law by themselves, by the judges, are not known. So they are just like, lost in the dark, so to say. There's another thing I wanted to stress with reference to what you said, with reference to consultants and the payment for the next 30 days for the work which will be carried out in the next 30 days, and the position of banks. Now, the problem that we have in Italy, or the problems that we are twofold. For one, normally, as we do not have this sort of culture of turnaround, the business to be prospectively rescued does not have any money whatsoever. So there's no way that they will find the money to pay, for instance, the consultants in advance. A second problem that we have from a perspective of banks this time, apart from the possibility to be granted the authorization, is that whilst we have a quite broad understanding of a liability, a civil liability related to a delayed filing of a petition seeking the adjudication of bankruptcy, we have an understanding which is relatively strict, or prospectively relatively strict, of the criminal sanctions related to, so to say, granting preferential treatment to some creditors, gläubige Begünstigung, which implies that no bank is willing, maybe a bank is willing to accept the risk related to civil liability, but is not willing to be exposed to the risk of having contributed to this sort of unequal treatment of creditors, which is considered to be a criminal sanction. And I think, especially for that reason, or also for that reason, we have the possibility that you can file an application without any further requirements. There's no plan, no composition plan that has to be handed in. You are granted, similarly to the insolvency plan, a certain term, 120 days plus 60 days. And at the time of the filing, you can be granted authorization, for instance, to just like make certain payments. So a bank will be willing to grant you some sort of bridge financing in these circumstances. So maybe this is something, I don't know if I understood you correctly, that could be discussed in Germany. But apart from that, I would like to, as we're talking about, preferential treatment of creditors and the position of banks, one of the main aspects, which is, so to say, a hidden privilege, especially for banks, is the whole issue related to the setting off of different claims. And as I know that you just like were criticizing quite a lot with reference to the setting off in particular, and we'll be talking then at a later date with reference to the closeout netting. Maybe, we should just move to that, right, sorry. Then let us move to the closeout netting immediately. Allora, scusate, passo all'italiano, faccio una premessa molto veloce. Allora, la disciplina della compensazione del fallimento in realtà è ovviamente nota. In Germania vigono gli stessi principi che noi abbiamo nell'articolo 56 della legge fallimentare. Quindi sotto questo profilo in realtà non ci sono differenze rilevanti. Una differenza rilevante invece fa riferimento senz'altro al cosiddetto close-out netting, alle clausole sostanzialmente di close-out netting. E a questo riguardo, a beneficio di tutti, posto che sono state previste in una direttiva comunitaria, sono state recepite a tutti gli effetti in Italia, faccio riferimento semplicemente alla definizione, poi cedo la parola a favore del professor Paulus, ossia si parla innanzitutto, per quanto attiene al decreto legislativo 2004 numero 170, del fatto che le clausole di close-out netting sono valide e hanno effetto in conformità di quanto dalle stesse previste anche in caso di apertura di una procedura di risanamento di liquidazione nei confronti di una delle parti. E per quanto attiene a queste clausole si definiscono, ai sensi della direttiva comunitaria poi recepita in Italia, alla stregua di clausole di un contratto di garanzia finanziaria o di un contratto comprendente un contratto di garanzia finanziaria, oppure mancanza di tale clausola qualsiasi norma giuridica per la quale, in caso di un evento determinante l'esclusione della garanzia, attraverso compensazione o altra modalità, si prevede la possibilità sostanzialmente per le singole banche di essere debitrici esclusivamente del saldo. Magari, you want to outline the close-out netting, or you want me just like, I leave it to you. No. Maybe just like one, maybe you could just like give an example of how it works, the master agreement.
I have to do it quick, right? Yeah. This is something which is fascinating. It's really fascinating. It's the work of lobby, and the work of the lobby institution, which is called ISTA, the International Securities and Derivative Association. They are enormously effective, and they do it behind the scenes, behind the veil. They hide it. They really hide that. And it's extremely complicated to find out. They have made more or less the closeout netting insolvency proof. Closeout netting means that if I have an agreement as a banking institution with you as a banking institution, we enter into a contract, a closeout contract, because we have hundreds of running contracts between the two of us. So it's derivative trading, it's repo trading, and what have you. It's all this kind of banking, commercial activity, what have you. And the two of us, you and I, we enter into a closeout netting agreement. That means that in the case of insolvency, all these contracts that we have, let's assume 100, are not any longer subject to the insolvency proceeding. If these 100 insolvency contracts between us, if they were regular contracts, the insolvency administrator would look, are they already fulfilled or are they not fulfilled? And then, dependent on if they are not yet fulfilled, they would enact, 72 of the Italian... 72 of the Italian bankruptcy code, and they would say, well, we decide for rejection or we want to have the fulfillment. They would make it, the administrator would make it for the benefit of the of the general creditors. The bank said, we don't want that. And for that reason, they pack it into this closeout contract, and all these open claims will be calculated together so that in the end there is just one claim. Let's assume you are, in the overall aggregated counting, you are in the money, then you have one claim against me. This is a little bit tricky, but it leads to an enormous reduction of the insolvency risk. I give you the real figures. The trading on the derivative market worldwide in 2009 has been $605 billion. $605 billion. It's quite a bit. If you look at the insolvency risk of all these transactions, the insolvency risk would be $25 billion. It's not shakingly high, but it is enormous. It's quite a bit. If you have a closeout netting agreement, the insolvency risk is reduced to $3.5 billion. Can you imagine? 605,000, the entire volume, insolvency risk normally would be 25 billion, and by closeout netting it's reduced to 6.5. And the ISTA, the financial industry, explained to selected legislators in this world, 60, in those days it was 40 different legislators, the big financial places. So it was the United States, it was Japan, it was London, it was England, it was Germany, it was France, it was Italy, all the European countries, and a number of further countries. They went there and said, and pushed, lobbied, that they had an enactment in the insolvency law that this would be introduced. And they justified it, if we don't have this privilege, our business is so complicated that we will that we will have systemic crises. So if one goes bankrupt, the others will follow. It was the usual range of argument that they bring, the world would go down. And the legislator believed it. And now here comes the interesting thing. The latest change in the United States was introduced in 2005. In 2005, the trading of derivatives jumped because of this legislative change from 3% to 18%. And guess what? This trading was one of the main reasons for the financial crisis. Explanation, moral hazard. And you can wonderfully see in the case of the Lehman Bank that this moral hazard worked. Lehman Bank had to pay within the first weeks 50 billion dollars to the creditors, to Goldman Sachs, even though it was in an insolvency proceeding, because of this insolvency proofness of this privilege. And nobody in the academic world, almost nobody, knows anything about it. That is amazing. You can't expect the legislator not to do it, because this is pressure. In Brussels themselves, you have 1,700 lobbyists just for the banks. So you can't expect the legislator. My appeal is to the professors, and to the judges. We have to be aware that there are unfair privileges and we have to do something about it.
Molto brevemente, anche per concludere, la peculiarità, quello che francamente disturba il professor Paulus di queste clausole di close-out netting, è che in realtà si prevede che la risoluzione del contratto avviene un istante prima del fallimento, quindi esattamente il contrario di quanto viene sancito come regola generale nell'articolo 72, il che implica che sulla base di un accordo si inseriscono, come dire, a mo' di pacchetti tutta una serie di contratti, centinaia di contratti tra una singola banca e un debitore. Nel momento in cui c'è l'inadempimento di uno solo che porti poi all'apertura di una procedura concorsuale, automaticamente sono risolti anche tutti gli altri. Per cui anziché considerare ogni singola posizione e fare il discorso relativo evidentemente al debito della massa e il credito verso il fallito, si fa evidentemente soltanto il saldo, il che, ripeto, è in netta violazione dell'articolo 72, comma quinto, e quindi garantisce in questa prospettiva di fatto un privilegio, un trattamento preferenziale alle banche. L'argomento di cui parlava il professor Paulus è evidentemente un argomento anche quantitativo, significativo. Io mi sono fatto, fatto riferimento ai valori per compararli anche al prodotto interno lordo italiano. Si parla di un ammontare complessivo di 605 mila miliardi di dollari. Il prodotto interno lordo italiano è 2.000 miliardi e il rischio cui sono esposte le banche da un fatturato complessivo o comunque una cifra pari a 25.000 miliardi di dollari a seguito di questa pattuizione close-out netting, peraltro recepita anche positivamente a livello comunitario e quindi anche italiano, viene ridotto da 25.000 miliardi a 3.700 miliardi. Questi sono dati ufficiali che il professor Paulus ha riscontrato. A questo punto non mi resta che ringraziare il professor Paulus, ringraziare gli organizzatori e concludere augurandomi, soprattutto in considerazione ovviamente del mercato transnazionale per quanto attiene ai derivati, che ci sia una sensibilità comune non soltanto in Germania ma quantomeno a livello europeo. Grazie.
Bene, una conclusione affidata a uno dei nostri relatori è davvero stata la prova di una condivisione di contenuti, di metodi e di partecipazione. Quindi davvero grazie anche a nome dell'OCI a voi che avete avuto pazienza e passione nel seguirci fino a questo momento. Arrivederci.